The jury has the Kyle Rittenhouse case, and their job got harder today. I'll explain why. Now, on one level, they are doing this with 500 National Guard troops on standby for any unrest in Wisconsin. And now you have to remember, this jury is not sequestered. In fact, we don't even know who's going to be deliberating yet. You have a group of, just under a couple of dozen people. The judge is going to pick which ones are the 12. And they're going to be able to go home. They're going to be told, hey, try not to follow any of the coverage of this, but they're going to be very aware of all the weight of expectations. That's heavy. So the atmosphere is tough, but so is the case. They got a lot of charges to consider, and they got extra ones today. And they came with an unusually confusing set of instructions that we'll take you through from a controversial judge who's absolutely an issue. Will he be for them? We'll see. Now, the judge threw out a weapons charge today. You're hearing a lot about this online. Look, the statute has a length for a weapon to trigger, no pun intended, the statute where it's too long to be carried. The judge determined that the weapon that Rittenhouse, the defendant, had, an AR-15, was not long enough to be prohibited under the state statute. So now the double homicides and the alleged attempted homicide have layers of lesser charges for the jury to consider. Why does the prosecution do this? The obvious, they're hedging. You get more choices. But that can be confusing for a jury, especially with the instructions they got today about what's okay and when do you look at this one and when do you look at that one. It's going to extend this process. I'll tell you that now. However, after we've heard the cases and the closings, we can now give you a good sense of the main questions. You ready? Was the defendant's presence and behavior at the violent protests or riots or whatever you want to call them, was his behavior in itself a provocation to the people around him? That's the key word. Was it a provocation? Why? Because if he provoked the situation, if he created the situation, you cannot claim self-defense as a cure to a situation you created. If the jury does not believe that he provoked the situation, and that is not unlikely, they then have to look at each incident of a use of force. Here, the firing of his weapon. They're going to have to assess with each of the victims in each situation. Sometimes it's with each bullet. I don't think that's going to happen here because they came in a very quick volley, less than a second. But did the defendant need to use deadly force to avoid serious injury or death in each instance he used the gun? Is it reasonable to them? Does it make sense? Did they say, if it were me, I would have? That's the key. What are the questions in looking at it? Were the people chasing him? Were they trying to hurt him? Were they trying to kill him? People observing the case outside the jury got really strong feelings. Some of them don't meet the facts. On the left, Kyle Rittenhouse, the defendant, was framed early on as an absolute vigilante. He's a villain. He's a righty. He's an extremist looking to shoot protesters that night. Something even he alluded to specifically a couple of weeks earlier, caught on video saying, hey, you see those people coming out, those looters? I would have shot them if I had my AR-15. Now, the jury never got to hear that, but the rest of us did, and it cemented an impression. The right paints him as a victim. He's a hero. He went there to help. He acted in self-defense when that mob came at him. Now, I've said this all along, okay? The coverage of this situation has not been great. It's steeped in political agendas. This was not an easy case for this prosecutor, and this prosecutor did not do a great job, okay? Neither of these portrayals that I've given you, who he is on the left, who he is on the right, neither has to find a home in this jury for them to find a verdict. And it could easily be the case that the defendant, while has no explicit burden, right? It's on the prosecution. But his team may have made, and with him in the chair, a stronger showing in their affirmative defense case than the prosecutor did in making theirs and meeting their burden. Remember, everything they put out about his self-defense and why he needed to do it, that was their choice. But here in this court, the prosecution has to prove to this jury, beyond a reasonable doubt, he didn't need self-defense. The main takeaway from the prosecution is provocation. That was the headline of their closing argument. Provocation invalidates the self-defense claim. Listen.
You're not allowed to run around and point your gun at people. This is the provocation.
This is what we see in the video. Him putting the fire extinguisher on the ground and then raising the gun.
That is what provokes this entire incident. And one of the things to keep in mind is that when the defendant provokes the incident.
Think back on November 2nd, when this case started. Did you hear one word out of Mr. Binger's mouth about provocation? You didn't, because it was never said. But when his case explodes in his face, now he comes out with provocation.
Now, that's not the defense's best pushback. The best pushback is that you didn't hear the prosecutor say, who did he point the gun at? Because if you're going to provoke somebody, you're going to point the weapon at them. They have to perceive that you're doing the provocative act. Otherwise, it's not a provocation. Did the prosecution make the case beyond a reasonable doubt to that jury that it was Rittenhouse who started what wound up with him firing the weapon at the same people? Did he do that? Why Rittenhouse was in Kenosha that night? So compelling in the media, so compelling to so many of you watching this. Came across state lines, AR-15, lying that he was an EMT. The prosecutor says that all makes him an aggressor. Listen.
Here's the defendant running in between those parked cars, slowing down, and you can see just how close, or rather how far away, Mr. Rosenbaum was when the defendant shot him. Mr. Rosenbaum is not even within arm's reach of the defendant when the first shot goes off. There's no way Mr. Rosenbaum could have taken that gun even if he wanted to. He is already falling to the ground. You can't claim self-defense against an unarmed man.
You can claim self-defense against an unarmed man. It depends on what the unarmed man is doing to you. Just because you have the gun doesn't mean that anybody else can't do anything. But was it reasonable? Is what he perceived reasonable in the mind of this jury that it needed to be responded to with deadly force? Because remember, he admitted on the stand, I used deadly force on purpose. Again, remember, this jury is going to hear all of this. The judge says, don't listen to the media, don't do any of that stuff. But they're not sequestered. They got people around them, they got lives. There's so much noise on this. What will filter through, what won't? Now, does being in Kenosha, this is the damning fact about this guy, right, that you hear all the time. He shouldn't have been there. He went there for bad reason. And he's got bad ideas in his head. Even if that's all true, does it mean he provoked the attacks on him? That's what the defense seized on. Here's their rebuttal.
We don't play fast and loose with the facts, pretending that Mr. Rosenbaum was Citizen A #1 guy. He was a bad man. He was there. He was causing trouble. He was a rioter. And my client had to deal with him that night alone. Mr. Rosenbaum was shot because he was chasing my client and going to kill him, take his gun, and carry out the threats he made.
The defense attorney actually said, now I've never heard this before, I'll ask the better minds in a few minutes. He actually said that he's happy his client, the defendant, shot and killed Mr. Rosenbaum. Because if he hadn't, he would have taken the weapon and used it on other people. Now, a closing argument has to be anchored to the facts, but there's absolutely room for speculation. And this judge, who, couldn't find enough opportunities to talk, let these guys go, didn't say anything. Now, that is a huge leap for this jury. I wonder if it bothered them, because there's no fact to support that Rosenbaum was going to take this guy's gun and start using it on other people. The only reasonable thing for him to argue is that he was going to use it on the defendant, Rittenhouse. Now, Rittenhouse's mother has been there, has been emotional, obviously, but she's also been working this case in the media, saying that gun that her son had, that they say is a bad thing, was a good thing. It saved his life.
A lot of people shouldn't have been there. And he brought that gun for protection. And to this day, if he didn't have that gun, my son would have been dead.
Now remember, He had no business being there. He should have never been there. And you shouldn't have taken him there, Mom. She didn't take him. And the fact that he shouldn't have been there is not what this jury is looking at unless they see his presence and behavior there as provocative to the same people, provoking the same people who chased him. Did the prosecution prove that beyond a reasonable doubt? Now, look, you can argue if he didn't have the gun, 2 men wouldn't have been killed and another's arm blown off. They showed the pictures in court. Horrible to look at. But remember, the judge said it was not illegal for him to have that weapon there. He removed the charge.